Alright guys, what's going on? So if you have watched this channel, then you have heard me talk about many instances where Frederick County, Maryland has not followed the MPIA or Maryland Public Information Act guidelines and have voluntarily withheld records that should have been disclosed when they were asked for them. We have talked about concealing body camera footage from the Frederick County Sheriff's Office. We have also talked about how the Sugarloaf Alliance had to sue Frederick County government to get records about Amazon data centers that were going to be built. However, it looks like this issue of government offices not knowing how to properly respond to MPIA or Maryland Public Information requests goes well beyond just Frederick County. In today's video, we are going to talk about a quite frankly embarrassing ruling against Washington County, Maryland that comes from the Public Information Compliance Board. So this issue deals with Washington County, Maryland trying to charge someone over $7,000 for records and how ultimately this compliance board ordered that Washington County had to reduce these costs by roughly 90%. So let's take you to that ruling right now, which again is quite frankly just embarrassing for Washington County government. All right, so here we are. This is the State of Maryland Public Information Act Compliance Board. This relates to a decision that was handed down on October 5th, 2023. This was in relationship to an individual named Justin Holder, who was the complainant in this action. He filed a complaint with the State of Maryland PIA Compliance Board, and this was an order that was issued on October 5th. So today is the 8th, so this is just 3 days ago. This order was released at the time of this recording. So let's talk about the quick synopsis of what's going on here. And it starts off with the first line. It talks about it. The complainant, Justin Holder, challenges the $7,602 estimated fee that Washington County has charged for responding to his Public Information Act request for sewer and water system related agreements between the county and 15 different sub-districts. So it goes on to talk a little bit about the background of the case. So let's talk about it briefly. In March of 2023, the complainant sent a PIA request to the county seeking the agreements to operate, construct, and maintain a sewer/water system that were made between the county and 15 sanitary sub-districts and, quote, signed and sealed on or before December 31, 1993. The county, through council, acknowledged the request and provided an estimated fee of $7,602.95 for the production of records. This is where things get interesting. So it starts off by giving a little quick side tidbit of information, and you should know this as well as the viewer. So it says the official custodian may not charge a fee for the first 2 hours that are needed to search for a public record and prepare it for inspection. So that's how it works in the state of Maryland. If you do a PIA request, whoever is the custodian of records has to provide the first 2 hours of work for free, whether that be review, preparing to inspect, to copy, to scan in, whatever it is they need to do. The first 2 hours of work are considered free. So if it's a very easy to satisfy public information request and it falls within the first 2 hours, you'll run into a situation where you're likely not to pay anything. But nonetheless, the first 2 hours of work when you submit a PIA request are free. And so the first 2 hours are free. And remember, we have this $7,602.95 bill for, which is outrageous, extremely high, but this massive bill to produce these records since 1993. And now it talks about, and I want to read this directly, the county's math
appears to be wrong here. It's talking about the 7,600 number. But it says the county's math appears to be wrong here. To arrive at the $7,602 estimated fee, the county multiplied $104.15 per hour by 5 hours to arrive at an estimate of $520.75 per each of the 15 boxes. It goes on. It says, after receiving the county's estimated fee, the complainant requested a fee waiver. The county denied the complainant's fee waiver request. It says, turning to the estimated fees challenged in this complaint, we start with the county's argument that the complaint is premature and thus warrants dismissal. We disagree. We are empowered to review allegation that a custodian has charged an unreasonable fee higher than $350. As we have explained somewhat recently, the operative word there is charged. It does not matter whether the fee represents an actual fee for work already performed or an estimated fee for work anticipated. The county seems to suggest that because it asked the complainant submit a deposit, that did not include fees for legal review, that it somehow had not charged him a concrete fee for responding to his PIA request. We see absolutely no distinction there. What matters is that the county demanded that the complainant pay, in its words, a deposit of $7,602. It moves on to say the only question before us then is whether that fee is reasonable, whether the $7,602 is reasonable. They say we think it is not. First, as explained, the county's method of calculating the estimated fee for search time grossly inflated that number. The county explained that it would need 2 employees to spend 2.5 hours each searching through the 14 boxes of records. The county combined the hourly rates of those employees and the total amount of time that they would spend searching those boxes to arrive at the $7,082 estimated fee set out in its May 23, 2023 letter. More specifically, the county multiplied the $104.15 combined hourly rate by 5 hours of search time per box to arrive at a per box estimate of $520. It then multiplied that per box estimated fee by 14 boxes, then subtracted $208 to account for the 2 hours of free labor that the PIA provides. Given that the combined hourly rate represents the pay of the 2 employees, the county should have multiplied that hourly rate by 2.5 hours, not 5. Otherwise, the fee represents the work of 5 hours per box for each employee, not 2.5. Thus, assuming no other issues, the estimated fee should be $3,436. And they go on. It says, but there are other issues. First, because the submissions left some questions unanswered. We asked the county to provide more information about the basis for their fee. They go on to say we also asked the county to explain why it was necessary to assign such highly paid employees to perform the search. The compliance board concludes that it would be more likely that bringing in a permits specialist would be the best option to satisfy this public information request. And they write, we think it is reasonable at this stage to anticipate that it will take a permit specialist an average of 2 hours at the most to search each box for the responsive agreements charged at a rate of $29.16 per hour and accounting for the 2 hours of free labor the PIA requires. That time estimate results in an estimated fee of $758.16. The most that should be charged for staff to perform this work is $29 per hour, and you can get lower level staff to perform the work. So what is that? What is the end result here? You go from a $7,602 bill to what turns out to be a $758 bill. And their conclusion is that based on the submissions, including the additional information about the basis for the fee provided by the county, we conclude that the deposit, the estimated fee that the county has asked the complainant to prepay is unreasonable, and direct the county to reduce that deposit to $758. So you go from $7,600 to $758. That's a 90%, essentially a 90% reduction from what it originally was. You know, they want to charge an exuberant amount for what is not an exuberant situation. And this is awful, you know? You don't want to see this. When you have this, this is indicative of corruption. I hate, I put that word out there. I mean, this is not an exuberant amount of work here. $7,600 to get what to me seems like basic records. It's not okay. People should not have to go through these long, drawn-out processes to get records. It's just absolutely outrageous. So you have the end result of a reduction in 90%. It's just insane. You have Frederick County doing it. You have Washington County doing it. And in Maryland in general, the people need to not tolerate this. This is our information. It's owned by us. We pay these people to store it for us. And these, unless it is an extreme circumstance, these records should be given for free. For free. We pay these people to house them, to take care of them. We already pay their salaries. Why do we pay for these things? It's just outrageous. Now, if something takes an excessive amount of work, that's a different story. And maybe this is one of those situations where it's okay to charge $100, $200, $300, $400. Maybe it's okay. But this right here, it stops the average person from being able to get the information that they need. This prevents a lot of people from even filing requests or even pursuing them because they don't want to get involved. They don't have the time to deal with this, and therefore they just go away. And that right there is the end result. Anytime you see a situation like this, it's just to get the public to leave them alone. Let's give them an exuberant fee for the MPIA request, and they will just go away. That's what they think. It's either laziness, it's corruption, it's nonfeasance, and it's outrageous, and the people of Maryland should not put up with it. We need to be more like Florida, who basically all their records are open. They have what's called the sunshine situation, where all their court records are open, they're online, they're digitalized. Maryland is very different, and we need to whip it into shape here in the great state or the not so great state of Maryland. Shame on Washington County for doing this, and shame on every other county and every other governmental institution in the state of Maryland that pulls this nonsense. And then in the end, when people fight you, you always lose. So that's where I'm going to leave it. We need to make Maryland a open and transparent state. And until we do, you are going to hear me sounding the alarm on issues like these. So, Levi Trumbull in Frederick County. I hope this video was informative and useful and shines a light onto how the MPIA is treated here in Maryland. Take it easy, guys. We'll catch you.